Hello, everyone, and welcome to today's webinar, Bhasin versus Hrynew, a 10-year retrospective. Today's session will run about 45 minutes with time at the end to answer questions, so please do post any questions in the chat box. Now, we've received a tremendous response to this webinar and are hosting a large audience today. If you do experience any technical difficulties, we suggest you exit the meeting and re-enter it using the link provided in the email. Rest assured that LexisNexis will distribute a recording of today's session in a follow-up email to you all. I am your moderator today, Cynthia Kohler. I'm the manager of external authors at LexisNexis Canada. Claire Buckley is also with us, and she really helped make the book that was inspired by Bhasin to happen. So without any further ado, let me introduce today's distinguished presenters. Jeff Hall is the author of Canadian Contractual Interpretation Law, now in its 4th edition with LexisNexis. Mr. Hall is a partner with McCarthy Tétrault LLP's litigation group in Toronto. Having been with the firm since his call to the Ontario Bar in 1993, he is a leading litigator and advocates in a broad range of corporate and commercial matters, including contract disputes, shareholder disputes, tax disputes, administrative law matters, Aboriginal litigation, and bankruptcy restructuring cases. Our next presenter is Brandon Kane. He is the author of Good Faith in Canadian Contract Law, which is going to be released by LexisNexis early next month in hardcover. He's a partner at McCarthy Tétrault LLP in Toronto. He is the head and co-founder of its National Appellate Litigation Group. He has a broad litigation practice which focuses on both private and public law. Mr. Kane has acted in over 20 appeals at the Supreme Court of Canada, along with numerous cases in the federal and provincial courts. And Angela Swan, who is the co-author of Canadian Contract Law, now in its 4th edition with LexisNexis. Ms. Swan is counsel at Aird and Bearless in Toronto. She taught at the University of Toronto as a full-time member of the Faculty of Law from 1965 to 1988. As a part-time member until 1993 at the Faculty of Law of McGill University from 1996 to 2002, and at Osgoode Hall Law School since 2003. Welcome to all of you. We're delighted to have you. Brandon, I think it might be fitting that we start this discussion with you providing a summary of Bhasin, the decision, but also asking you why the decision was the catalyst for your book.
Thank you very much, Cynthia, and thank you very much to Jeff and Angela for participating in this webinar today. So traditionally, Canadian courts had not developed any sort of uniform or overarching approach to good faith in contracts in common law Canada. This obviously changed with the 2014 decision in Bhasin, where the Supreme Court recognized what it called a general organizing principle of good faith in contractual performance. And the organizing principle basically means that you should perform the contract honestly and reasonably and not capriciously or arbitrarily, by paying appropriate regard to the legitimate interests, contractual interests of your counterparty. And it's not a fiduciary standard. It doesn't require you to subordinate your own legitimate interests to those of the counterparty. The court held that this principle is not a general duty of good faith in the sense of a freestanding source of liability. It's more of a background standard, like freedom of contract, for instance, that is manifested and informs various specific doctrines of contract law, which are freestanding sources of liability. And you generally need to show that your claim would fall within one of those existing doctrines of contract law in order to recover. And for the most part, those doctrines are ones that pre-existed Bhasin. They existed in particular types of relationships, like employment or insurance agreements, or in certain situations like the exercise of discretionary contractual powers. Bhasin confirmed that those traditional duties continue to exist. But it said that they are now bound together by this general organizing principle of good faith. And it recognized that this principle can actually give rise to new doctrines of good faith in certain situations. And it ultimately recognized such a new doctrine in Bhasin itself, in the form of the duty of honest performance, which is essentially a duty that prohibits a party from lying or otherwise knowingly misleading its counterparty about matters directly linked to the performance of the contract. And so this is a duty that applies to all contracts in common law Canada, irrespective of the party's intentions. So not something the parties can contractually exclude. And if the duty is breached, the innocent party can seek damages from the breaching party based on the normal contractual measure. And that was found to have occurred on the facts of the scene itself, where damages were awarded. In terms of how it influenced my book, it was certainly, I think, the catalyst for my book. I had thought about writing a book on good faith in contracts even prior to Bhasin, but I had not begun doing so. And certainly, if the decision had gone a different way than it did, I may have concluded that no book was necessary. And so, but Bhasin did go the way that it did. And certainly, once it came out, it became clear to me anyway, that a book on good faith would be, useful, I think, to the Canadian legal profession. And it fundamentally changed the way that I think about good faith in contracts. I realized after Bhasin, the subject was a lot more nuanced and pervasive in the law of contracts than I had previously thought. And so it triggered my decision to write the book, and it was very much central to the topics and structure in the book.
Mm. Now, Angela, did Bhasin change anything?
It changed one thing, and that was it stopped people talking the nonsense. The Alberta Court of Appeal talked when it decided the Bhasin case, where they said there's no such thing as a duty to perform in good faith, independent. But it didn't change anything because, as Brandon has just said, what Bhasin said is that you don't tell lies. And on the facts of Bhasin, the defendant was in trouble because he told a flat-out lie. And so, don't tell lies is hardly a novel kind of statement of principle. And so, Bhasin, because if you look at the broad sweep of contractual cases, good faith comes up all the time. As I put it to my students, and to anybody I speak to, don't be a scumbag, because courts don't like scumbags. If they can get scumbags, they will. And the person who doesn't behave and perform in good faith is a scumbag. And so, that, as I said, if you look at the cases, lovely case in the Ontario Court of Appeal called 100 Main Street, in which John Morton, judge whom I greatly respect, though imposes an obligation on one of the parties to a contract to facilitate the contract, because that's the obligation it assumed when it made the contract. And so examples after example can be found to show the courts doing exactly what was done with good faith. In fact, Brad Crawford, and we all know, died not long ago, very tragically, wrote an article looking at banking cases and concluded that Bhasin didn't change anything. Results of the cases were the same, whether or not Bhasin had been decided. And so what bothers me is the argument that comes mostly from academics that somehow there's something wrong about good faith. It's some kind of foreign thing, which reminds me that almost 30 years, now 40 years to the day, I published one of the Law Society special lectures in which I made a comment which Tom Cromwell picked up, namely that English courts, Canadian courts regarded good faith as a bit like having an embarrassing social disease, not to be mentioned. But Bhasin then changed the kind of the boundaries of the discourse, but didn't in fact change much in terms of actual result of the cases.
Jeff, Brandon, any comments on whether Bhasin changed anything?
I'm on mute. There we are. For my part, I think it did. Although there is much to be said for Angela's view that it didn't change a lot of the results. It changed the discourse, and it changed the thinking about contract law a book like Brandon's excellent volume, that's 2 volumes that are coming out very shortly, wouldn't have been possible without Bhasin. And Bhasin has caused a field that was quite ad hoc and not well conceptualized to be conceptualized. It's had a bit of a difficult history, which I'll go through a little bit later when I have a chance to speak about interpretation in particular. But it is a seminal case. It has changed the way we think about contract law, and we are very fortunate that there's now a book that examines it in great detail, something that would not have been possible without the case.
Brandon?
Thank you. No, I completely agree with those comments. I mean, I think Bhasin has had a number of effects on the law. And some of them are obvious, like the fact that there's now a duty of honest performance where there wasn't previous to Bhasin, at least in its current form. And some of them are more subtle. And you know, I just focus on a couple of those. I think Bhasin is important in characterizing good faith as an organizing principle. I think this is a useful way to think about contract law. You know, a lot of us sort of come out of law school believing that contract law is largely a series of black letter rules, like offer, acceptance, consideration, contra pro forentum. But the reality of contract law is actually a lot more complex. There are larger principles, you know, that underlie the rules that affect how they're created, interpreted, and applied. And good faith is one such principle, and there are other important ones as well that Bhasin highlights, like freedom of contract and commercial certainty, that can come into conflict with one another and have different weight and different contexts. And so I think Bhasin is important in recognizing this reality and encouraging us to think about contract law in that way. It really, in my view, vaults the sophistication of contract law in Canada forward. And the other point I would just highlight is I think it's greatly increasing the importance of bi-jural legal analysis, particularly at the Supreme Court, where you have cases like Callow and Wastack that are relying on the civil law of Quebec to develop the common law, and cases like Churchill Falls and Ponce that are relying on the common law to develop the civil law. I think that's an important development and is in part attributable to the Bhasin decision.
So Jeff, let's bring you back to contractual interpretation. Has Bhasin changed that at all?
Yes, very much so, although in various different ways over various different times. You need to understand a bit of history to understand how Bhasin has affected contractual interpretation. Prior to Bhasin, as Brandon's already noted, the black letter rule was no duty to perform in good faith. The parties' obligations and rights were derived entirely from the agreement and couldn't be modified or supplemented or altered by concepts of good faith. However, the courts had developed a series of exceptions, including the one that Angela mentioned that Justice Morton developed, where they came up with circumstances of injustice, where they needed to have a duty of good faith to make things work and to make things fair. By the time Bhasin came out, 2014, there was an ad hoc list of about 13 or 14 exceptions to the black letter rule that there was no duty of good faith. Was not conceptualized, was just ad hoc. And what Bhasin tried to do was to give an intellectual structure to that and to allow the court to go forth in that regard. And if you set it in the context of interpretation, that made sense because contractual interpretation had moved over a period of a number of decades from a very literal approach looking at just the four corners of the agreement to a more contextual approach that looks at factual matrix and the commercial efficacy and things like that. The immediate reaction to Bhasin by the lower courts was very negative in the field of contractual interpretation. There was a great fear that Bhasin would be used by litigants and by courts to change bargains after the fact. And they were very, very hostile to the point that good faith became very much a tenuous argument in terms of any sort of interpretive issue. The principle was then reinvigorated with the two Supreme Court decisions in Callow and Wastec, which once again looked at these doctrines, but rooted them much more in the particular bargain that was chosen by the parties, and modified Bhasin to that effect of not being quite so external, but very centralized on the bargain. So what we now have is a field of interpretation that's quite different than it was 10 years ago. Good faith is front and center, a key principle, a fundamental principle, as I call it in my book, and one that affects the interpretive process, but in a sort of marginal way. There's a lot to be said for what Angela said, that many of the results of individual cases might not be all that different, but it is conceptualized differently than it was more than 10 years ago.
Brandon, Angela, do you agree with those statements?
I got some problems with it because if you look, for example, at what Lord Blackburn said in the House of Lords in, was it 1881, the high point of kind of black letter law. Lord Blackburn says in a case called Mackay and Dick, I think that I may safely say, as a general rule, that where in a written contract it appears that both parties have agreed that something shall be done, which cannot effectively be done unless both parties concur in doing it, the construction of the contract is such that each agrees to do all that is necessary to be done on his part for the carrying out of that thing. There may be no express word to that effect. That looks like to me a statement of kind of good faith. And I point out in my text that Lord Blackburn found support for this proposition in a case decided in 1469. And what surprises me is that case is kind of ignored. It seems to me to make it clear that there's an obligation of good faith to perform to make the thing work, exactly the same as the Court of Appeal did in 100 Main Street. And so I just think that the problem that people have with good faith is a problem of ideology as opposed to actual law. They believe that there shouldn't be the kind of good faith mushiness. It makes the common law uncertain. There's a British position has been, or the English position has been for some time. I just think that's just not true. I don't think it makes things mushy. I think it fills out what the parties expect. So,
Brandon?
Well, no, I mean, I think those are both great comments. And, I just going back to what Jeff was saying about, the relationship between interpretation and good faith. I mean, you can certainly see good faith as part of, a bit of a larger trajectory of the law of contracts over the last, couple of decades, that it's moving away from a more formalist, sort of will theory approach to contracting, where, as a matter of interpretation, you're starting to look at a lot more factors and assumptions and concepts beyond just the words on the page. I think SATVA is very much, obviously emblematic of that. And, it's interesting, SATVA was on reserve with Bhasin for several months. They were decided together, although Bhasin doesn't refer to SATVA. I think they influenced one another quite a bit. And you could view, the assumptions of, the need for trust and honesty in commerce that underlie cases like Bhasin as very much drawing in certain respects on the factual matrix and the reasonable expectations of the parties. I think there's a lot of common themes in those areas.
Okay. Angela, what about pre-contractual negotiations? Is there a duty of good faith with them?
Of course there is. When Bhasin came down, my custom with my firm, I gave a seminar to the firm on the effects of Bhasin. And so when I told the solicitors in the firm, they said, so what? With respect to negotiations, how can you expect to have a satisfactory relation if your negotiations haven't been conducted in good faith? It's as simple as that. And so good faith, and there's lots and lots of cases where courts have bounced people around because they didn't negotiate in good faith. And so to say that Bhasin doesn't touch good faith, I think is just a misunderstanding of it, because it says the same thing. Good faith is inherent in all kinds of things we do, because it's quite clear from the cases that you can't, for example, snap at an offer you know to be mistaken. So that's an example of the court saying you can't take advantage of someone's mistake because that's a breach of the obligation of good faith negotiations. And so I think that the people who, going back to the English House of Lords and so no such duty, I think are just misunderstanding what actually is going on. As I said again, I think it's an ideology. The ideology that nothing exists until the contract is signed. That's simply not true. All kinds of obligations arise long before the contract is made. A good example is the Australian High Court decision in Walton Stores. Okay, where the tenant was held liable to the landlord because it let the landlord believe he's going to sign the lease. And the Australian High Court found that that was unconscionable conduct and imposed liability on the tenant for the landlord's damages. And so there's all kinds of cases where the courts have imposed a duty of some kind before the moment when, in traditional theory, the contract will be performed. So Bhasin doesn't change anything, and it clearly applies to negotiations.
Any other views on that from the panelists? Jeff?
Well, yeah, I don't totally agree with that. Not the first time that Angela and I haven't totally agreed, but that's very healthy. Bhasin, by its terms, it relates to contractual performance. And so breach of the duty of whatever duty of good faith there is, whatever one is at play, is a breach of contract. And that can't happen before there is a contract. So to the extent that the claim is Bhasin applies directly, I respectfully disagree with that. I do, however, completely agree with Angela's excellent point that conduct matters. And she puts it very colorfully, very accurately. Courts don't like scumbags. And that does pervade the court's examination of parties' conduct. And particularly since Bhasin, I do think Bhasin has changed that part of it, that there is now more scrutiny on parties' behavior, and it might be part of a larger trend, as Brandon suggests. And I think Bhasin has had that incremental effect, but it's, in my view, indirect, not direct.
So Brandon, why don't you elaborate for us the impact that Bhasin has had on other duties of good faith?
Yeah, no, happy to do so. So obviously the major duty of good faith that was at issue in Bhasin is the duty of honest performance. But it's had an impact on, other duties of good faith since that time that fall under the organizing principle. And there's a couple of points that just emphasize. So first, in 2021, we have the decision in Waste Tech, where the Supreme Court recognizes, or to some extent confirms the fact that there's a duty to exercise contractual discretion in good faith. And Bhasin exerts a bit of a structural influence on how contract law works and how the court in Waste Tech frames this duty. So, first the court frames the duty in Waste Tech as a mandatory one that parties can't contract out of, rather than as an implied term. And it does so in part because Bhasin did the same thing with the duty of honest performance, and the court in Waste Tech is saying, one of the things we want to do here is create alignment and coherence among these different duties. And so prior to Waste Tech, it wasn't clear if that duty was an implied term or not. After Waste Tech, it's clear that you can't contract out of it. Another, reflection of this is that the court in Waste Tech said that the content of the duty is one that requires you to exercise discretion reasonably. So there were cases prior to Waste Tech, Greenberg and Mefford at the Ontario Court of Appeal being a good example, that had said that the duty to exercise contractual discretion in good faith included subjective and objective standards. So it required you to act honestly and it required you to act reasonably. And in Waste Tech, you see the Supreme Court recognizing that, we already have now, after Bhasin, a duty of honest performance that applies to all contractual rights and obligations. And so it would be superfluous to, say that the duty to exercise discretion in good faith also requires you to act honestly, because then you'd have two duties that could impose honesty in relation to the same thing. So in order to accommodate that development in Bhasin, they formulated this duty as one that focuses on reasonableness. And so it's just another example, I think, of the fact that, you see Bhasin starting to, have significant impacts structurally on how contract law develops. I guess the other way it's affected duties, just going back to the points that Jeff and Angela were talking about, is in relation to contractual negotiations. And so, one of the things I try to do in my book is draw a distinction between contractual formation, being where parties, negotiate and actually successfully form a contract, and then one party says that, oh, you engaged in improper behavior during the formation process, and they try to rescind it. That's one level. But then there's also unsuccessful contractual negotiations where they try to reach an agreement, but they just are unsuccessful in doing so. And there's really two different bodies of law there. Like, so for formation, there's a whole bunch of doctrines like the one Angela was referring to, like unilateral mistake, duress, unconscionability, that for hundreds of years have policed the formation of agreements that I would suggest are very much part of the organizing principle of good faith. And then you have, what Jeff was referring to, where you don't have an agreement. And so, how do you have a duty to negotiate in good faith? There are some cases that say if you have a pre-existing or a preliminary contract and you negotiate under that for like a renewal, perhaps, or, an annual rate reset, or, to formalize the terms of a letter of intent, there can be obligations to act in good faith under that pre-existing or preliminary agreement. And we start to see courts now applying Bhasin to sort of define what those duties would be.
So Angela, you would say that there is always a duty of good faith in whatever form the pre-contractual negotiations take. So I'd like to hear your views on what Brandon sort of described as what he views as the evolution of law and the parameters of where good faith comes in at what point in the process.
Well, traditional contract doctrine says there's no relation between the parties until the offer is accepted. And that's simply not true. There are all kinds of cases where the courts have dealt with problems arising before that point, have imposed on parties obligations before the contract is actually made with the acceptance of an offer. I mentioned the Australian High Court case of Maher, and where the tenant led the landlord to believe that he was going to sign the lease. In reliance on that statement, the landlord then demolished the building to be ready for the lease. And I think the solicitor for the tenant said, you can safely walk away because there's no contract. And the court said, no, you can't do that. Okay? You can't just let the landlord believe that you're going to have a lease and then say, ha, fooled you. And again, parallel to don't be a scumbag, courts don't like people who say, ha, fooled you, because it doesn't comport well with what people think. Courts think that how people should behave. And so, as I said, I think the problem comes from the fact that people have an ideology, and we can't shake that ideology. I don't know why, for example, the academics have such problems with good faith. They keep saying it doesn't no role to play. Well, that's nonsense. Any practicing lawyer knows that behaving badly is not a good plan. I always advise my students, don't be a scumbag, and don't advise your client to be a scumbag, because it doesn't work out well. So I don't think, so good faith is right there. Okay, by the way, I just think that the more important case than Bhasin actually is Callow. I think Callow is a wonderful example of the court, an image I have. You have people laughing and saying, oh, look, poor Callow thinks he's going to get a contract, and we know he's not going to get one. And the court says, you scumbags, we're going to make you liable because you led him to believe he was going to get it, and now he suffered loss. And so Callow is a lovely example of the court saying, you scumbags, you can't get away with this.
Brandon, would you agree with that?
I mean, I certainly would agree with the sentiment behind what Angela is expressing. Having argued the Callow case, I think that probably is part of what was going on. I think it's a little bit, nuanced in that in Callow, what was going on was, a dishonest exercise of a termination right under an existing agreement, where the dishonesty was, something that flowed from, misleading statements that were made about the renewal, perhaps, of a future agreement. And so it's kind of an interesting example of how, conduct during contractual negotiations can still result in liability under an existing agreement. It just shows, I think, kind of the complexity of this area.
Jeff, do you have anything to add to that?
Don't think so. No, it's been fully canvassed. I don't think I have anything to
Okay.
add.
All right. Well, Angela, I'm going to ask you now if there are any major distinctions of the good faith principle among the common law provinces and Quebec that you can share with us.
I don't think there is. Again, you have, because this thing is so tied up with an ideology of contracts, as opposed to kind of looking at the thing in a realistic way. Again, just to toss in something which Jeff and I discussed for some time, I think that if you focus on contracts as being for the protection of expectations arising from promises, reasonable expectations, I think a whole bunch of the problems fall away, because focusing on expectations lead you then to, I think, easily the correct result. But I think that back up. I like the fact that in both Caro and WasteTech, the decision was drafted by Nicholas Casero. I think that in Canada, we have this wonderful opportunity to learn, Jeff mentioned it, or maybe Brandon mentioned it, from the fact that we've got two legal traditions in the same country, and each could inform the other and make something really powerful and important and useful. I think that Russ Brown's objection to Caro is simply kind of silly. Why do we care whether things can? The common law has for centuries, picked up stuff from all kinds of places to bring into it and to then guide people to the conclusion. And so I like the idea that we're coming closer to the civil law concept of good faith, to the civil law concept of contracts. So.
Jeff, do you agree with that?
Yeah, generally do. I'm not a Quebec lawyer, although I do cover Quebec law in my book to some extent. But my understanding is that good faith has been a pervasive concept in contract law in Quebec much longer than in common law. An instance actually where the courts were ahead of the civil code, but it's now codified and it pervades all aspects of contracting, including the pre-contractual negotiations part. And I do think we are in a good position in this country of being able to draw upon that expertise. Bhasin expressly said that one of the things that they were trying to do is to look to the Quebec experience and maybe not unify the law, but learn from that experience in terms of importing it into the common law. And I do tend to agree with Angela that we have two rich legal traditions in this country, and too often we have two silos that aren't listening to one another as much as they should. One of my most interesting experiences as an advocate was arguing the Fairmont case. Don't anyone look that up because I lost, but the Fairmont case and rectification, but it was bundled with a Quebec case and it was argued together. The Quebec case first, argued in French, the Fairmont case argued in English immediately after in the same hearing. And both decisions conceptualize the issue differently, but leading to the same ultimate result. And we should be probably doing that more than we do.
Anything to add, Brandon?
No, I mean, I think Jeff is bang on in terms of referring to those cases, and I think actually, because I refer to this in my book, the companion case to Fairmont, is it John Couteau?
Yeah.
The Supreme Court in that case actually refers to the example of good faith as being, another instance of convergence between the civil and the common law. And so, I think it is, an important feature of the Canadian legal system. And it's one of the things I think that makes Canadian law unique is that, we have this ability to, obviously we're heavily influenced by, English contract law, but can see it perhaps in a bit of a broader light in light of the civilian influence. So.
That's great. Now, Brandon, any comments on the application of this to employment law? this was a question that was submitted in advance, so we thought we'd ask you to tell us what you think.
Sure, happy to give you my thoughts on that. And I just preface by saying I'm not an employment lawyer, so take what I'm going to say with a grain of salt. Although I certainly try to talk about employment law and good faith in my book. And so, I would say a couple of things. First is good employment law played an important role in Bhasin itself. At the time Bhasin was decided, one of the clearest analogies, that Mr. Bhasin could point to was the Supreme Court's prior decisions in Wallace and Keyes, holding that employers owe a duty of good faith in the manner of dismissing employees. And that was really, a recognition by the Supreme Court that there could be requirements of good faith in a case where a party is exercising a right to terminate a contract. And so naturally, I think the Supreme Court cited that case law in Bhasin, and we see aspects of it influencing the duty of honest performance. Like, for example, in Callow, you see the Supreme Court saying, the duty only limits the manner in which the termination can occur. It doesn't limit whether you can exercise the termination right. That's similar to how they framed the duty that employers owe in dismissing an employee. It's something that concerns the manner of dismissal. It doesn't impact the reasons the employer may have in deciding whether to exercise the dismissal right. So there is that close relationship. And since Bhasin, you've seen cases in which, Bhasin has then in turn influenced the employment law duty. And so I think the main case would be Matthews and Ocean Nutrition, 2020 decision of the Supreme Court, where, the court held that, in addition to an employer owing a duty of good faith in the manner of dismissing an employee, employers are also subject to the duty of honest performance. And so, and that just follows from the fact that the duty of honest performance, as Bhasin sets out, it applies to all contracts in common law Canada, irrespective of the party's intentions. And so there can be multiple duties now after Bhasin in the employment context. The other thing that the court in Matthews leaves open is whether or not, there may even be a broader duty of good faith in the employment context in the form of, I think they call it a reciprocal duty of non-fiduciary mutual loyalty, is sort of the type of language that's being used. And, it's not decided in Matthews. They don't say whether that exists or not. They simply note that it's possible, and they leave it open for a future case. But it's very much rooted in Bhasin, the fact that the court is willing to consider the possibility of that. And so I think that suggests that Bhasin has had and is likely to have, depending on how that duty is developed, or if it is developed, a significant impact, I think, on employment law. So.
Thank you. Jeff, are the obligations of good faith any different for governments than they are for private entities?
Yeah, this is a great question. We got it in advance, and I kudos whoever sent it. It's a great question. A couple thoughts come to mind. One is, I think that the courts often overlook governmental perspectives in contracting. I had a very interesting experience a number of years ago presenting on interpretation to two government groups, an in-house Ontario government group and an in-house federal government group, and both of them kind of bristled when I got to talking about commercial efficacy, because they say the courts always get it wrong when governments are involved. They don't understand how governments work, and they are they look at commercial efficacy from an entirely private sector perspective, driven by the profit motive and all that other thing, and just misapprehend what governments are doing when they're contracting. So that's one thought in how good faith can assist in mitigating that problem. The other thing that comes to mind, and Angela and I spoke about it briefly before, is the honor of the crown, the concept in Indigenous law that is so pervasive in Indigenous law, and of course so familiar to, or so similar to a duty of good faith, that the express connection should really be made in the contracting process. And I'm only aware of one case where that has been done, a case from the Yukon Court of Appeal earlier this year that expressly held that principles of good faith from Bhasin applied to the interpretation of an intergovernmental agreement between a First Nation and the government of Yukon. And I would not be surprised if there's more of that. I think there probably should be more of it. And it's a good example, in my view, of how good faith can enrich contracts and interpretation to lead to fairer, more accurate results by reflecting the reality of the relationship between governments and people with whom it deals.
Angela, do you want to add anything to that?
Well, I just point out that as a taxpayer, I'm enraged when the government behaves so as to attract punitive damages, which happens far more often than it should. They behave badly, they think they can get away with what they want to do, and they shouldn't do that. And the extent they are subject to an obligation to behave themselves, the idea of good faith, I would think that has to follow from it. And I think, again, Jeff and I were talking before the show we started, again, I agree with Jeff that the honor of the crown has to be kind of an aspect of how you behave in this particular situation of the government with respect to First Nations. And I don't think the government should be treated any differently than any other contracting party. If the courts don't understand the government position, then you have the government to put evidence in to get that position established. So I completely agree with Jeff.
Well, I notice we have a lot of questions in the chat, and before we turn to them, any final comments, observations from our presenters? Angela?
I want to say something I don't think has been said before. I want to congratulate Brandon, because so much of how the law develops depends on what counsel put before the court and give the court an opportunity to consider. And I've been arguing for probably, well, I go back a long way, 30 years or so, for recognition of an obligation to perform in good faith. And Brandon achieved it for me. And so I want to congratulate Brandon for having the courage to do that and to put the issue before the Supreme Court of Canada on a more useful kind of plane or argument than had been the case in the Alberta Court of Appeal. And so much depends on counsel. If counsel doesn't give the court what it needs, the law won't change as it should. And so I want to say both great gratitude to Brandon and appreciation of Brandon's work, both in starting with Bhasin, but also in Callow and so on. So I want to congratulate Brandon for having the courage as a litigator to do what had to be done to move the law forward in a constructive and profitable way. So thank you, Brandon.
And if I could just add a thought to that, I totally agree with that sentiment. And I would add that it looks forward as well, because the courts and practitioners are affected by legal thought. I've had the advantage of seeing an advanced copy of Brandon's book, and I recommend it to everybody. I think it will affect the development of the law in this field in a very positive way, giving structure to the field. So I suspect, Brandon, that your contributions that Angela talks about are not just in the past in cases that you've argued, but in the future in terms of reliance by the courts and litigators on your excellent book that will be forthcoming shortly.
Oh, wonderful. Let's jump into the questions. I'll start from the top. I'll ask you, Brandon, can you compare the duty of good faith under Bhasin with that under the Civil Code of Quebec?
Yeah, I mean, it's a great question. And I mean, I think I would start by saying, there is no duty of good faith under Bhasin. There's an organizing principle of good faith under Bhasin. And this is one of the main differences between common law Canada and Quebec. Whereas under the Civil Code of Quebec, you have a duty, a general duty in Article 1375 and Articles 6 and 7 that impose a general requirement of good faith. And there are various, manifestations of that duty, which would include things like, a duty not to be dishonest, a duty to cooperate, some cases a duty to inform. It's different under the common law because, again, you don't have a general duty. What you have is a background standard, a principle of good faith. And under that, there are specific duties like, the duty of honest performance. And many of them parallel, frankly, the manifestations of the general duty in Quebec. but it's a different, theoretical structure. If you can't fit your claim within an existing doctrine of good faith under the organizing principle, you can't recover unless you can establish that a new doctrine under the principle should be recognized. Whereas in Quebec, you do have this residual duty ability to, shelter under the more general concept of the duty as being an obligatory legal obligation. So I think that to me is probably one of the biggest things. There's a lot of others, some of which are talked about in my book, but I think it would be a very long discussion. So
So Brandon, the next question, what are the parallels between good faith in contract law and the unlawful means tort? And then they go on to ask, can good faith provide the courts a better ability to deal with the unlawful means tort, given the somewhat inconsistent rulings from the appeal courts in both Canada and the UK?
Well, I'll do my best to answer that question. I mean, it's a very incisive question. What are the parallels? I mean, I guess, as a starting point, it's helpful to note that in Bhasin, the Supreme Court, picks up on the AI Enterprises decision that Justice Cromwell had written earlier the same year, recognizing that, the duty of good faith doesn't prevent a party from causing loss to someone else intentionally, even as long as they're acting in their, legitimate economic self-interest. What it prohibits is inappropriately disregarding the legitimate interests of the counterparty. And at the root of both of those, those cases, I would say, is really there's a limited role that AI Enterprises emphasizes for the courts in the common law to impose economic liability, because there's concerns about commercial uncertainty, interference with the market economy, those sorts of things. And that is something that very much underlies the restrained way in which the unlawful means tort is developed in AI Enterprises, and why the unlawful means element is given a very narrow definition. That's a similar sort of concept that I think underlies some of what, influenced Bhasin and how it framed the organizing principles. So there's a common philosophy of what the judicial function is in relation to economic liability, I think, that underlies both settings.
Angela, Jeff, anything to add to that?
I don't think so. I don't think so.
No,
Jeff?
don't think I have anything to add either. So,
All right. Next question. Re-inducing someone into performing in anticipation of a contract, could this not properly be dealt with under the doctrine of negligent, fraudulent misrepresentation? Brandon?
Sure, happy to try to answer that, and would love to know what Angela and Jeff think about that. I mean, I guess it would depend. So we're talking about a negligent or fraudulent misrepresentation that would induce performance, but it would induce it in anticipation of a contract. That could be dealt with under the doctrines of negligent or fraudulent misrepresentation. It could also be dealt with under estoppel, concepts. One of the aspects I think that the duty of honest performance is interesting for is, some people have asked, do you really need this duty? Because you could simply have liability for negligent misrepresentation. And, in some cases, it's difficult to have a duty of care in a contractual setting. Courts are reluctant, I think, to impose duties of care where a contract is present. So, the ability to kind of have liability for some of these concepts that Bhasin is recognizing, provides an additional, armory, I think, to litigants. But certainly there, even prior to Bhasin, there's a lot of cases dealing with liability, in tort for pre-contractual misrepresentations. I think Queen and Cognos would be a good example of that.
Angela, anything to add to that?
I tell my students that the essence of the lawyering function is the choice of the peg on which to hang an argument. A client comes in, tells you a sad story. Your job as a lawyer is to say, okay, how do I put this story into a legal context? What pegs do I have to get my client the result that it wants? And so you look around and you see cases in which obviously the litigator has chosen one peg rather than another. And that has serious consequences. But you see it coming up in cases like oh goodness, I'm having a senior moment. Construction case in which the bank told the contractor that you advanced enough money to the owner to build a building, and so I was involved with Blake's with it, and we put our case on the basis of a contract, grade A contract. Bank promises to advance enough money, and the consideration for the bank is it gets the money, it gets the interest on the loan. We saw that as a simple peg to hang an argument on. If you go to Canada, Madam Justice Wilson said, no, it was too short for a contract. It's only a page. Contracts are longer. And so they went down a misrepresentation. No, just choose a tort peg. I said, it all works. She gave awarded damages based on the opportunity cost that the contractor incurred by not getting a properly paid contract. And so throughout the law, we have these alternatives, and they have consequences. And so I give my students a big table, with course of action across the top, what you're going to prove, the consequences, and so you choose that depending on what you want to get. And so I just think that the existence of alternatives is just a feature of the law because that's how it works.
Jeff, I'm going to ask you the next question.
Alrighty.
In the Civil Code of Quebec, the duty of good faith is twinned by a duty not to use one's own rights in a manner inconsistent with good faith. Bhasin and Callow have essentially recognized the duty not to abuse one's contractual rights, but there remains a question about whether statutory rights, including those implied into a contract by operation of statute, must also be exercised in good faith. Even absent a statutory obligation such as Section 4 of the Securities Transferred Act or 4.2 of the Bankruptcy and Insolvency Act. So the question is, what are your views on the potential expansion of the duty of good faith in this direction?
It's a very interesting question. I would be skeptical of the crossover from the contractual realm to the statutory realm. All of what we've been talking about in terms of good faith today has been in contract, which raises very different social issues than statutes. Statutes are public by nature. They involve policy considerations that are public in nature. Contract, very different policy considerations. So to me, the divide is a broad one, a pretty broad gulf, and hard for me to see that would be crossed. But as Angela says, all you need is a peg as a litigator. So it might be an interesting argument for someone to advance at some point. I haven't seen it done before. Advancement of the law comes from creativity. So it's possible, but looks to me like a challenging argument.
Brandon, anything to add to that?
Yeah, I mean, I think, there are some provisions, and Jeff would know this much more than me in terms of the insolvency world, but I think under the CCAA and the Bankruptcy Insolvency Act that require good faith, I think, in certain settings. And so I could certainly see courts maybe at a theoretical level drawing analogies to cases like Bhasin and Callow and saying, well, what do those provisions mean? But the cases that deal with the organizing principle of good faith, most of the formulations that you see of that principle in Bhasin, Waystek, and Callow talk about it applying to the exercise or performance of contractual rights and obligations. That's very much, I think, the trigger for the principle and the duties and doctrines under it, generally, unless you're in the contractual formation phase. And so if you're exercising statutory rights and obligations, I think it's a little bit of a different calculus. And I don't think that those, certainly directly, I don't think that they would apply.
Angela, do you see the potential expansion here?
I have nothing used. I can there's nothing I can usefully add.
Okay. Okay. So Jeff, I'm going to go back to you with this next question. Has Bhasin or any case following been successfully applied in contract negotiations regarding fixed term contracts, such as, well, we've sort of touched on the employment, but do you have anything to add to, in terms of this question, to add
Not
to that?
not a whole lot other than what we've already said. I do think that the effect of Bhasin on anything pre-contractual is pretty indirect. And just to tie this perhaps back to a comment a few questions ago, talking about negative misrepresentation, fraudulent misrepresentation, that question demonstrated that the pre-contractual realm is primarily a tort realm, and if liability arises, it's generally, not always, but generally in the tort realm. So I do see a divide at the point of contract formation where you go from a predominantly tort regime to a predominantly contract regime. That's not completely watertight, and there are exceptions and some crossovers. But to me, the effect of Bhasin on any sort of pre-contractual negotiations, not within an existing contractual structure, that is different, whether it's in the employment context or otherwise, is pretty minimal, pretty indirect.
Okay. Next question. Could the panelists touch on how the duty of good faith may inform courts' applications of the TURCON framework to exclusion clauses? Who wants to try answering that?
Dear me, Turcon's a very disappointing decision. The background to the problem is two things. First is the Supreme Court's bizarre focus on its role as a guardian of the tendering process. That is, in my view, cost Canadian taxpayers billions of dollars by complicating unnecessarily the process by which governments get things done, public procurement. Second thing about TURCON is the purport to deal with the ridiculous problem of fundamental breach. Trouble is, if you don't understand what you're trying to kill, it's hard to kill it. Fundamental breach involved the court saying, we can perceive the essence of a contract for a used car. Regardless of what you say, we're going to impose upon you that contract. That is no basis of a business for a court to do that. The problem was English courts tried to protect consumers, and they had nothing to hand. They rejected unconscionability. Legislation didn't help. And so Lord Denning cooked up this utterly bizarre idea. Everyone else and pulled the forelocks and said, yes, we're going to follow that. It's utter nonsense. And TURCON is a ridiculous case because both the majority and the dissent see their role as policing public tendering. Public tendering doesn't need that policing because the tendering process itself has all the controls you need. If governments misbehave and put on too many terms, too onerous terms, they won't get bids or get higher bids. And so the market itself will police it. So TURCON, I don't know what the hell it does, but it didn't do what it should have done. Sorry, I get angry with TURCON. So.
Well, thank you, Angela. We can get with the final question in the insurance context, policies are subject to utmost good faith. What does Bhasin add in that context? Brandon, can you give us a quick answer on that?
Yeah, no, happy to address that. There's a lot of obligations of good faith in the insurance context. There's obligations on insurers and there's obligations on insureds. The obligations on insurers are ones that apply in the performance of the agreement, and they've attracted a lot of attention in cases like, Witten and Fiddler, where, if an insurer acts unfairly in, dealing with a claim, they can be subjected to punitive damages. You do start to see cases after Bhasin where courts have started to rely on, the obligation of honest performance, and just generally, the description of the organizing principle in Bhasin perhaps as a non-fiduciary standard as informing, the obligations of insurers in fairly handling claims and when punitive damages will be available. So I think it's important in that regard. And then it's also, there are obligations on insureds. So at the stage of forming the insurance contract, they have to make, disclosure. at the performance stage, there's an ongoing duty of honesty by insureds. When they make claims, they can't submit fraudulent claims that are based on untrue facts. That's an area where I think it's interesting to consider, how the duty of honest performance will apply, because in certain respects, the duty of ongoing honesty by insureds is very much a subset of that, although it's one that predated Bhasin. And so you could certainly see that being developed in a way that's, intended to bring it into greater alignment with the broader duty of honest performance. So.
Well, that's terrific. It's 101. I want to thank our terrific panelists. We covered everything from where duty of good faith arises in pre-contractual negotiations to the honor of the crown in Indigenous law. It's been terrific. The questions were wonderful. Thank you, audience. And I hope everyone has a delightful day. Thank you again.